citizenship. There are the citizens that live at the common law, and there are the citizens that live at the national law, or what is called Admiralty and Maritime Jurisdiction. Now, the way they get away with putting this Title 26 and this Title 27 out, the way they do it, is they create this Admiralty and Maritime Jurisdiction, and if you volunteer into it, you are in it. If you step in it, it's on you. Okay? So I'm telling you, don't do that. You know what the doctor says? Every time you go to the doctor and you say, "Doc, every time I do this, it hurts." You know what the doctor tells you? He says, "Don't do that no more." You don't do that no more, it won't hurt, right? I'm telling you the same thing applies with this. Don't volunteer. How do you volunteer? You enter and you watch what you sign, number one. Any evidences of contracts where you are in Admiralty or Maritime Jurisdiction says that you are a party to the contract. So you avoid that. When you sign that bank draft to get into that bank and that Section 9 form you fill out, guess what? Look at the bottom. You sign to get into an Admiralty Maritime Jurisdiction. What the hell would you want to do that for? It's illogical. When you signed up for that Social Security check. So, how are we going to remedy this situation? 1-207. Without prejudice. You sign anything that has to do anything with those guys, take the rights if they'll give them to you. Take the benefits. But make sure when you sign it UD 1-207 without prejudice. And that makes you a common law citizen. And when they pull you into these courts and they claim they have jurisdiction over you, you say, the first thing out of your mouth is, "Your Honor, may it please the court, before this matter goes forward, I wish to state that I am here on a special appearance as distinguished from a general appearance, and I am answering in the form of a demurrer." A demurrer is an old way of pleading. It's an old-fashioned, old-country, barrister English way of pleading without granting jurisdiction. In other words, I'll answer out of courtesy, and I'll give you an answer out of courtesy, but at no time am I granting jurisdiction. Now, I put on my briefs, I state my name, I state the defendant in propria persona, on a special appearance as distinguished from a general appearance for jurisdictional challenges. Now, I've raised the issue of jurisdictional challenges. I'm putting on the record. It's clearly cognizant. Once jurisdiction is raised, the burden is on the plaintiff to prove jurisdiction pursuant to McNutt v. General Motors Acceptance Corporation, recorded at 56 Supreme Court 502. It says, jurisdiction may never be assumed, but must be substantively proven by the plaintiff claimant. They don't prove it in a timely fashion, laches incurs. Laches is a species of action wherein a party of reasonable intelligence and integrity having a right to take an action as is prescribed by law, and having failed to timely do so, loses all right to proceed. So if they don't prove it timely, motion to dismiss, Your Honor, failure to state a cause of action for which relief can be granted, and I'd kind of like to collect my costs and fees for having to defend this frivolous case. Does that make sense to you? All right, now, let's get into this Erie Railroad case. This is a railroad case. What it's about, the guy was walking down the track and a board was hanging off the end of the train and whacked him upside the head. He tried to sue in the state courts. The state courts hammered him. So what happened was, Erie Railroad had flipped around and they tried to sue him in the federal courts to get back at him. And they thought they were pulling a fast one. And what happened was the case bounced back on them. And guess what? When it bounced back, it created a very, very dangerous thing. Now, before this, I want you to understand that for 100 years of law, this case was the one that was the leading case before this. And this was called McCulloch versus Maryland, the state of Maryland. This is a very leading case. This is the most heavy case. It comes in 2 sections. That tells you how thick it is. So you're going to be reading for a while. This case upheld for 100 plus years, practically almost 100 years. This case is recorded at, where are we at here? Where is the site? The site is, come on, give me a break. It's page 316. What is the volume? You guys are messing with me. You see a volume in there? Well, let's see what they call out here. They call up the beginning of the case. Well, we'll get you the volume. I should know it by heart, but I don't. Let's see if we can get it. It's a 1819 case. It is an old case. And it upheld for years the single citizenship relationship. And it deals with corporations. The power of establishing a corporation is not a distinct sovereign power or end of government, but only the means of carrying into effect other powers which are sovereign. whenever it becomes an appropriate means of exercising any of the powers given by the Constitution to the government of the United Union. It may be exercised by that government. Now, basically, it sets up relationships. The Bank of the United States has constitutionally a right to establish its branches or other offices in discount and deposit within any state. All right? The state within which such branch may be established cannot, without violating the Constitution, tax that branch. All right? Now, it goes into some heavy arguments on taxes and some other arguments on programming, but I'm telling you here, this was the law of the land. I want to get a cite on this for a reference. This book was so old when we got it from. It should say what volume it is, but it doesn't. Normally they put it in the case and then they'll cite it one time and then they'll say everything after that supra. They stated it at the beginning. Alright. Volume 4. Volume 4. No, wait. That's not really a good... That's probably... See, these reporters in the early... This is 1819, folks. That's when this case came down. So this was going to be... You know, shortly after the Constitution was signed. 1791 is when the Constitution was signed, so it's going to be an early case. Alright, William McCulloch, defendant, below in your branch. Normally they state the case one place and they state it. But anyway, to make a long story short, McCulloch versus Maryland is a very heavy case. It was the law of the land and it was replaced by Erie Railroad versus Tompkins. There is no federal, can you see that? There's no federal general common law. Congress has no power to declare substantive rules of common law applicable in a state, whether they be local in their nature or general, whether they be commercial law or in part of the law of torts. And no clause in the Constitution purports to confer such a power upon the federal courts, except in the matters governed by the federal Constitution or by acts of Congress. The law to be applied in any case is the law of the state. Got me? And whether the law of the state shall be declared by its legislature in a statute or by its highest court in a decision not a matter of federal concern. Now, in disapproving the doctrine of the Swift versus Tyson, the court does not hold unconstitutional Section 34 of the Federal Judiciary Act of 1789 or any other act of Congress. Title 26. It merely declares that by applying the doctrine of that case, rights which are reserved by the Constitution to the several states have been invaded. Invaded. That's why they can get away with having Title 26 without having no asterisk. They don't have to have it in law. They're claiming it's an act of Congress. And if you voluntarily enter into it, guess what? You bought the whole farm. A federal court exercising jurisdiction over such a case on the ground of diversity of citizenship. What am I talking about? Diversity of citizenship. I'm talking about dual citizenship, right? Is not free to treat this question as one of so-called general law, but must apply the state law as declared by the highest state court. Swift versus Tennyson, overruled. The liability of the railroad company for the injury caused by negligent operation of its train to its pedestrian on a much-used beaten path on its right-of-way interstate, right, along and near the rails depends in the absence of a federal or state statute upon the unwritten law of the state where the accident occurred. Now what they're trying to do here is they're trying to justify the existence of this duality of citizenship between common law citizen, which you are, most of you, and this natural national citizen, which would fall under Title 26 United States Code. But I'm telling you to look up Section 6331A of Title 26 and you will see that the Secretary of Treasury has jurisdiction only over corporations, officers of corporations, and officers of government residing in the District of Columbia and artificial corporation, who are contractors of the fund. Capiche? Alright? Now this is an important case. If you guys are going to be in this seriously battling and want to argue jurisdiction,